Okay, let's dive right into this explainer. Today, we're unpacking one of the absolutely most consequential public corruption cases the Gulf region has ever seen. I'm talking about the stunning, almost unbelievable downfall of Qatar's former finance minister, Ali Sherif al-Emadi. This whole situation is a profound case study in what happens when you mix immense public authority, state-linked institutions, and astronomical flows of money. 5.6 billion US dollars. Just let that sink in for a second. That is the staggering amount laundered by a sitting finance minister. We are talking about some low-level petty procurement fraud here. No, we are looking at a systemic siphoning of wealth that literally requires a highly sophisticated financial infrastructure just to move and hide it.
And the consequences were equally unprecedented. In January 2024, a Qatari court handed down a severe 20-year prison sentence to al-Emadi. Historically speaking, high-ranking officials in Gulf states have been way less likely to face open criminal proceedings compared to folks in the private sector. So this public trial and conviction, it's a massive, massive institutional event.
But wait, it doesn't stop there. The financial penalties didn't just match the laundered amount. The court actually slapped him with a fine exceeding 61 billion Qatari riyals. To put that in perspective, that's roughly 16.7 billion US dollars. That includes double the amount he laundered, plus extra fines on top of that. It's a totally historic penalty that really hammers home the sheer magnitude of these crimes.
So here's our roadmap for today. First, we'll look at the 5.6 billion conviction, then the anatomy of public corruption. After that, we'll cover why conventional controls fail, rethinking PEP risk, and finally, building a resilient defense. All right, let's jump straight into part one, the 5.6 billion conviction. You have to understand, al-Emadi was not some peripheral behind-the-scenes guy. He was embedded at the absolute very top of Qatar's financial architecture. He got appointed as finance minister back in 2013, but his tenure came to a screeching halt in May 2021 when the attorney general ordered his arrest. He was instantly stripped of all his government duties. Fast forward to March 2023, he's facing trial for bribery, appropriation of public money, and money laundering, all leading up to that jaw-dropping sentencing in January 2024. Which brings us to a really fascinating question, right? How do you hide $5.6 billion in plain sight? Seriously, how does that kind of money just move through the global financial system without setting off every alarm bell imaginable? Well, to figure that out, we really have to look under the hood at how high-level corruption actually functions. Moving on to part two, anatomy of public corruption. Things like bribery, embezzlement, and abuse of office. They all create different legal issues, sure. But in practice, they often converge into one giant, massive laundering structure. The initial transfer might be totally disguised through legitimate-looking government accounts, then layered through complex international investments, before eventually making its way back to the beneficiary. And the true catalyst making all this possible? It's something called institutional concentration. See, al-Emadi wasn't just the finance minister. He simultaneously chaired the Qatar National Bank and sat on the board of the Sovereign Wealth Fund. The real danger here is this toxic blending of official discretion with immense financial authority across multiple different touchpoints. He basically held all the keys. But here's the kicker. He didn't do it alone. High-value corruption on this kind of epic scale absolutely requires a network. There were actually 15 co-defendants in this trial that even included a former chairman of Qatar Hospitality who is a member of the ruling family, and he got a prison sentence too. This is exactly why those isolated customer-by-customer compliance reviews just totally fail. They completely miss the intermediaries, the connected accounts, and the corporate vehicles that are actually moving the dirty money. Which leads us perfectly into part three, why conventional controls fail. So, why do standard anti-money laundering programs miss billions of dollars? Well, the source material identifies 6 critical failure points. First, in sovereign finance, multi-million-dollar payments offer a plausible transaction scale, meaning they just look completely normal. Second, when ministries are involved, they have this institutional legitimacy that basically gives them a free pass from scrutiny. Add in data fragmentation across different banks, and ownership opacity hidden behind offshore trusts, and you've got a real mess. Plus, internally, you have management deference, where frontline staff are frankly too intimidated to question powerful officials. All of this allows corrupt proceeds to easily hide as mixed wealth right alongside legitimate income. As the source material points out, government branding often creates a really dangerous illusion of safety.
Think about it. A payment coming from a state-owned enterprise looks super credible, right? It easily bypasses frontline scrutiny. But that completely ignores the fact that the actual person authorizing that payment might be improperly enriching themselves or their associates.
Let's look at part 4, rethinking PEP risk.
When we talk about handling politically exposed persons, or PEPs, we've got to do more than just run a name against some static database. There is a critical distinction that compliance teams get wrong all the time, and it's the difference between source of wealth and source of funds. Look, just because a minister has legitimate, immense wealth from a successful lifelong career, that absolutely does not explain the origin of a newly transferred $10 million chunk of cash. Accepting vague descriptions like government income without demanding real, proportionate evidence, that is a massive vulnerability, especially when you're dealing with state-linked actors who literally control national budgets.
We have to transition away from this lazy checklist culture and move towards a truly evidence-led approach. This means ditching static name screening and moving to dynamic updates the moment a PEP's role actually changes. We also have to stop blindly assuming that anything state-linked is automatically safe and instead focus on the true economic purpose of the transaction. And honestly, above all else, that frontline deference we talked about, it has to be replaced with the independent escalation of high-risk activity, no matter who the client is or how powerful they seem.
And finally, part 5, building a resilient defense.
So, how do financial institutions actually protect themselves against this? Well, they have to build what we call a resilient control stack. It starts with the risk-sensitive identification of PEPs and their close associates. Next, you have to rigorously separate and prove their source of wealth versus their specific source of funds. Your defenses also have to include analyzing state-linked counterparties to really understand what their normal transaction profile looks like, and combine that with network monitoring to spot shared ownership across accounts. Finally, any changes in a PEP's office must trigger immediate event-driven reviews. And all of this has to be backed by senior escalation pathways that have total 100% operational independence from any commercial pressures.
If you take absolutely just one thing away from this explainer today, let it be this. Status never substitutes for evidence. Public authority never removes accountability. A robust financial defense doesn't have to assume every single official is corrupt, but it absolutely must demand that complex financial flows actually make sense, regardless of the powerful names attached to them. I'm going to leave you with one final thought to chew on. If a commercially important, highly influential, state-linked client moved millions of dollars through your institution tomorrow, would your program actually have the true operational independence to challenge it? It's a really tough question, I know. But as this $5.6 billion case proves beyond a shadow of a doubt, it is literally the only question that matters. Thanks so much for joining me on this explainer, and keep asking the hard questions.